think that since it was heard over public airways, that he's not got a prayer. It's public domain.
Okay.
If in advance he'd already had it copywritten, I don't think it would be public domain. So if he spoke of it on the air, I would hope he had the sense to have it copywritten.
Okay.
Someone else?
Okay. Okay, well, a good head start there. I guess maybe a threshold question is, what does it take to get something copyrighted? And probably easiest for me to read, copyright is proof of authorship and legal protection for the creators of artistic works, including visual arts. According to the 1976 Copyright Act and the Visual Artists' Rights Act of 1990, artists control decisions about the reproduction and public displays of their work. So understand that your artwork is automatically protected by copyright immediately after creation. So you don't have to put the little C at the bottom with a circle. You don't have to register it with the Copyright Office, which is part of the Library of Congress, for a very small fee, by the way. It's somewhere in the area of $35. So upon creation, upon putting pen to paper or paintbrush to canvas, it's already copyrighted. Now, what this author hadn't done is he hadn't put pen to paper yet. He was just talking about an idea. And ideas are not protected. So if somebody had the wherewithal to take his idea and turn it into a book, they would be free to do so. Now, if by putting pen to paper or paintbrush to canvas, we've already achieved copyright, why go to the additional step of the paperwork and the filing fee?
I think they would do that because it makes it so people know about it. That way other people won't do it by mistake and make the original artist angry.
Right.
In case of a lawsuit, then they'll be able to have evidence filed away that they have created that thing.
Yeah, exactly. On both accounts. What good is it to have ownership of something but not be able to prove it? So that if you've created a beautiful painting or written a beautiful book, but you can't prove that you did it, it's not much good. So one of the ways to protect your creation is to register it with the Copyright Office. You can do it online. It's about $35. The other reason is, so proof is one reason. The other reason is attorney fees. If you have registered your copyright, you're on the road, and you win, you're on the road to getting attorney's fees. By not registering it, you perhaps lose that opportunity.
When you copyright something, if it turns out that what you're trying to copyright is a copy of something that has already been copyrighted, how would they know that? Or do both people get get a copyright?
Right. No, you can only. That's a good question. Can two people get a copyright on the same thing?
Very similar, like the picture we saw of the Indian. Can that second person get a copyright on his version when it was based so much on the original?
Okay.
I guess my question is pretty much like, where is the line between being completely influenced, like she said, the Indian photo, and actually copywriting? Where's the defined line between that? Obviously, he was pretty much influenced by the Indian head, which is where his photo was based off, I guess, whereas he still lost the case. Like, I don't understand the difference between both.
Somebody earlier, I don't remember if it was Jessica or Professor Pearl, but they talked about how blurred the line is when it comes to that whole notion of is it significantly similar, and that they do have something called the guy on the street test, but that's a legal test. So it's not hard and fast as far as when something is exactly a copy or not. Okay. In terms of legal standing, okay.
Angela, do you want to give additional explanation related to this, where the copyright ends?
Right. Well, sometimes, of course, what happens is a court battle, and that's what we don't want to have happen. I perhaps come at it just a slightly different way. Oh, and that is going back to the question of why this even exists. And there is a history behind it, and copyright law has not been changed that many times throughout history. You know, long ago when somebody created a work of art and there wasn't a printing press to duplicate it, we didn't really care about it. But once things became easily duplicated, now artists and people who created original works were very concerned about what's happening to my artwork or what's happening to my literature. And the reason the law stepped in to protect it is really a matter, if you will, of creativity. And it extends not only to literature, I'm so sorry. It extends not only to literature, but also, what if you invented the fax machine? And somebody from another country bought a single fax machine and took it to their country, undid it, called reverse engineering, and constructed it and claimed right to it. So what if you invented something and somebody through reverse engineering could undo it and then redo it and claim it as theirs? Why wouldn't we like that? Well, because we see a lot of commercial value to that, right? I think artists at first see less commercial value and more creativity to what they produce. But in the legal sense, the law wants to promote creativity, whether it be through technology like fax machines or through fine art. And so the creator of that, whatever it is, should have the right to the ownership and therefore to the duplication, to the licensing. And when it gets too fine of a line, you know, it's sort of like I know it when I see it, the judges decide.
Yeah, I would like to ask a question first. My question is, when the copyright issue entered legislation? That's the one. And the second, about this fax machine and the visual arts, does fax machine falls into the category of the protection of the patents, which is a little bit different field, and the visual arts are going the other way, I would say.
Well, there is, that's interesting you bring that up, because there is a similarity in a sense. There's something called a design patent that does apply to artists. For example, I'll just read the question. Can you stop others from copying artwork or craftswork that borrows from nature? Many artists draw upon nature for their artwork, yet protecting such artwork from copying is tricky. The basis for the rule is that you can't claim rights to the nature, that is birds, bees, flowers, and the like, because they're in the public domain. So an artist can't copyright the spotted pattern of a leopard. A taxidermist can't copyright a stuffed leopard, etc. Now, in 1987, Banana Republic was allowed to use animal heads in their retail stores that were similar but not identical to those of Peter Rochelle, a maker of synthetic animal heads. A candle maker made candles that looked like corn, and they were exact duplications of corn. And so when somebody copied it, he had no protection. So is there the reason that this intellectual property somewhat runs together is one of the things you might be able to do if you can't copyright something is perhaps get a patent design on it.
I wonder if either Angela or the art and music faculty could address the issue of creative people having a moral obligation to, for example, not participate in bootlegging DVDs or watching them and other such issues.